Welcome to my channel, All for Health with Jane. Family, some delays in the Senzo Meyiwa murder trial are unnecessary and unfair. In the first clip in this video, we're going to listen to Judge Ratha as he explains what the Constitution says as far as delays are concerned, especially unnecessary delays. So let's listen to Judge Ratha after he realized that the defense is causing unnecessary delays.
In terms of the Constitution, accused persons are entitled to a speedy trial. This section speaks about unreasonable delays, and these can apply to the state, the defense, even to witnesses. Now, here we have an expert, ballistic expert, witness expert, ballistic expert, who gives evidence in August, and this is forensic evidence. And then it takes 8 months to cross-examine him, but I don't even know it's going to happen this year. It's unfair on that witness because he's seized with other matters. But the unfairness is predicated on the fact that in the pursuit of the other evidence in this trial, the cross-examination also impinges upon the evidence of this witness who has given evidence in August, and he's not being cross-examined on that. So that percolates to the unfairness of the process, because you can't say, for instance, ballistic expert Mgomezulu put it to Manganyi this and that, and Manganyi said this, and this answer is taken up by Ramosepidi, for instance, that it's a contradiction. You can see, you don't have to be a lawyer. 8 months, no cross-examination. And then in the meantime, we are proceeding with the other evidence, okay? So this impinges on the freedom of the constitutional right of a client like the accused here to have a speedy trial. And if there is a bottleneck, which is precipitated by either the defense itself or the legal aid board in not assisting in the payment of the costs of the ballistic report, which the defense say is important for their proper defense of the accused, then this court is obliged to investigate. It doesn't have to be a formal investigation if you read that. Now, if the legal aid board say we must talk about this in chambers, it is against the law. My recitation is, I won't do anything which is against the law. So Mr. Mujuta, when he comes, if the blockage or the delay is predicated, I don't want to say the negligence, on the administrative capacity of his department, he must say it in open court. Because if you read that, section 342A, it also involves the public interest and the interest of justice. Okay.
Family, then the legal aid board official is being called to court only to find that the information that was given by the defense to court is different from what the legal aid board assistance is saying. This lady says they only submitted the application about 2 weeks back. And when they said since August, they were busy trying to do applications for this finance for their ballistic expert. So what a delay that has been caused by the defense family. You know, it's a long time, and which is being unfair, not only to the court, not only to the Meyiwas, but unfair even to the accused persons themselves. So let's listen to the legal aid official as she presents that to the court.
Isola from Legal Aid South Africa is here.
Okay, it's Mrs.
Mrs. Flavio Isola.
Flavio Isola.
Yes.
You are from the Legal Aid Board.
I am.
Which position do you?
I'm the head of office.
The
Head of office
head of office.
for the Pretoria local.
Okay. Yeah, I received your message that you requested that we should meet in chambers. And I told Mr. Baloyi that I am not able to because I want to commence a preliminary inquiry in terms of Section 342A of the Criminal Procedure Act. When there is a susceptible delay in the proceedings, what predicates that delay? I just want to find out. And it's an informal thing. You don't even have to swear to tell the truth. It's just, if you read Section 342A, they say it's an informal inquiry. Just to find out what happens. I'll tell you, there's a witness called Manganyi. What's his first name, the gentleman?
It's Colonel Mangena.
Yeah, sorry, yeah. Colonel Mangena. He's a ballistic expert. He gave evidence in this trial in August last year. When the cross-examination had to commence, the defense requested that it must be adjourned until they have consulted their own expert. And thereafter, obviously, that expert will also prepare a report, whatever. And then they will be able to take the matter up by cross-examining this gentleman who gave evidence for the state. Now it's 8 months. That has not happened. By any standards, when you read Section 342A, if there is a delay which prejudices the state, the defense, even the witnesses, even the public in the interest of justice, they say it's incumbent upon the presiding judge to investigate the exigencies which are currently making it difficult for this case to proceed. I'm told by Advocate Mnisi that initially the intention was that the accused, that is the defense, had instructed the defense that they, the accused, will make attempts to fund the costs of hiring an expert, a ballistic expert. This, I'm told, ultimately hasn't happened. But subsequently, I'm told an amount was paid by some of by your client, is that not so, Mr. Nisi?
By the family members, jointly.
Yeah, fine, by the family members jointly. But that amount is still deficient. It doesn't make up the exact amount which is demanded by your expert. Am I correct, sir?
That is the position.
Now, I thought, because the accused have enlisted the services of the legal aid, ordinarily you would infer that they don't have the money to pay for a ballistic expert. And they subsequently advised me that they applied to the legal aid to bridge the deficiency which is short in terms of the payment or the cost which is demanded by the ballistic expert. Now, all I want to know is that correct, that an application has been made to the Legal Aid Board to fund the ballistic expert report and the cost of the ballistic expert giving evidence in this court?
That is correct, my lord. They did apply
When did they apply, ma'am?
on the 5th of April
This year.
this year, yeah.
That's the problem.
2 weeks ago.
Yeah, you see, that's the problem because, as I say, in August, this is what they told me they're going to do. Now, you say they applied on the 5th of April.
That's correct.
So what is happening now?
We received the email and we immediately responded,
Yeah.
because in terms of the procedures of policies and procedures of legal aid,
Yeah.
and when a duty care practitioner applies for expert, they must get permission to do so.
Yes.
And obviously they must set out the grounds why they require an expert. And also they need to submit a costing of such an expert.
Yes.
The reason why we require costing, because in terms of our approval framework, different levels of approval obviously is made.
Okay.
So if it's, for example, under 50,000, I can approve it at the local office. If it's between 50 and 350,000, it must go to provincial office. And if it's above 350, it goes to the CCMC, which is the Constitutional Case Management Committee. So it really just, and that's why we need a value of the cost.
Sorry, just to chat it, was the value not finished?
Not yet.
Not yet?
No.
So it's just an application to say, can you please give us some subsidy
No.
to defray the costs of the legal ballistic expert? There is no indication that this gentleman's costs are the following.
Nothing.
Preparation, it's so much. Drafting the report, it's so much. Attending court, it's so much. You don't have that type of thing.
And in fact, in our response to them, when we asked them for the cost,
Yeah.
we broke it down for them.
For them.
In consultation,
Yes.
perusal, drafting
Yes.
reports, appearing in court,
Yes.
Even disbursements like traveling, things like
That's
that.
it, yeah.
And we actually set out in the email exactly how we want the costing. And yeah, it hasn't been forthcoming.
Okay, fine. Thanks. So, Mr. Nisi, are you the spokesperson for your colleagues?
I'm not a spokesperson, but basically what Legal Aid Board said was that the counsel who's representing the client that the state is alleging that a firearm
Yeah, quite.
was found in his possession should be the one that
Yes,
is taking
yes,
the
yes.
center stage, yes. So in this instance, it's going to be me.
So, what's going to happen now?
My Lord, it's true that the Legal Aid Board has not yet been furnished with the information that they would need for the purposes of costing. However, I don't do that myself. I'm also relying on the expert. I've been in communication with the expert, but I've got reasons to believe that he could be engaged somewhere else.
I mean, cell phone. I hear they say President Biden phones Cyril Ramaphosa.
Excuse me, my Lord?
I hear that President Biden
Yes,
can phone Cyril Ramaphosa, President Ramaphosa in South Africa,
yes.
when he's at Phala Phala.
That is what we have done, my
And
Lord.
now you can communicate with the expert. Where is he? In Australia? Where?
No, he's here in South Africa.
In South Africa?
Here in Pretoria.
Ah, no, that's worse.
But my Lord, it is not really entirely accurate that I can't communicate with him,
What
because
is-
that is what we have actually been doing. Unfortunately, we don't know what is it that is delaying him, because the delay as of now, it is on his part. But we have just confirmed yesterday that we need that information as soon as possible. And in fact, I had requested in the email that I've dropped him that he should liaise directly with the Legal Aid Board South Africa. He should directly send that information to Legal Aid Board South Africa. But now Legal Aid Board says, no, they don't work like that.
Yeah.
He must do things through me. That's information that I did not have. And then I requested him yesterday, after I received that information from Legal Aid Board South Africa, that he needs to direct that quotation to me, and then I forward it to Legal Aid Board South Africa. He's busy working on it now, my Lord. It is not as if we have not done anything.
Yeah.
Yes.
So what's going to happen? Because let me tell you my worry.
Yes, my Lord.
You know, actually, forensic evidence is very sensitive.
Yes.
Okay? You can't expect a witness to wait 8 months to be cross-examined. When he comes there, I can't remember. I don't know if I did it because it's so long. I think I've got a good mind. I don't remember the evidence.
We really appreciate that, Mother. I
So,
really appreciate
Just
that.
listen to me. I'm
Yes.
also going to make an order that everybody here
Yes.
should go over the evidence which was adduced on behalf of the state, which was tendered by Mr. Manganyi.
Colonel Mangani,
Yeah.
yes.
And even you must refresh yourselves about the evidence which he tendered to be able to cross-examine.
We've got records to that effect.
Yes,
Yes.
I know. Yesterday, Mr. Ramusipidi couldn't remember whether there was a letter written by the station commander. It was who?
I was corrected.
It was who? It was who? Somebody else?
Yes.
Okay, we shall not mention the name. You see, that's what worries me.
Yeah, that is true, Mother.
So what must we do? What is the way forward now? How many months do you need?
We definitely don't need months, my lord, because we already have a preliminary report. However, there's a suggestion that we have as defense that in the interest of time, and probably that will cut a lot of time, that the two experts, that is now after Mr. de Klerk, our expert is Mr. de Klerk, after he would have completed his report, then he will consult with Mr. Mangena with the permission of the state, of course, Mr. Manganyi, just to try and curtail issues by way of, what do they call it now, through joint minutes. Agree on certain things, and then we come to court and deal with those issues that they do not agree on. In our view, we thought that would go a very long way to curtail the processes. But in any event, my lord, in as much as the court has indicated that we with time memory lapse does happen,
Yeah, when
most
you're
of the time
cross-examining.
forensic evidence is contained in papers, and they've got computers and everything. They can simply go back to the report that he has, and then he can refresh his memory.
I've heard of
And I'm not trying to justify
I've
the
heard of
delay,
evidence
my lord.
getting
Yes.
lost.
Excuse me, madam.
I've heard of evidence getting lost. Have you ever heard of that?
Then it means we're in a terrible state with
Yeah,
our
I've heard of
ballistic
evidence getting lost,
laboratory.
etc., etc.
If evidence can just be lost willy-nilly. But that is the position, man. We hope and believe. Because now, Legal Aid has also undertaken that as soon as they get that information, that's what Mr. Michuto told me yesterday, that it might not take 2 days to go through the application with an approval and or without an approval. But maximum will be 2 days, and then we'll get the result. And once we get the result, he will then say to us, proceed with Mr. de Klerk. It's not like Mr. de Klerk is going to wait up until such time that he gets paid. Once we get the go-ahead, we request him to consult with Mr. Mangena on the issues that he feels is necessary for him to consult with Mr. Mangena on, and then we take it from there. Unfortunately, I'm not in a position to determine as of now the period at which we can expect him to be at court with the report already in his hand.
So how long should we postpone for the evidence of Manganyi to be cross-examined? How long? I don't know. You should know.
Probably, my lord, I think it will be a prudent thing if we meet.
Yeah, how long?
If
time frames?
If there's from where I'm standing, say almost a week or two.
I'll give you a month. How's that?
That will be fine, my lord, but that is going to happen even before that,
Yeah, we'll see.
as it is the court, my lord.
Ma'am, is it okay a month? I know you're not supposed to liaise with them. It's not, that is a procedure.
Yeah. No, my lord, it depends on how much the quote comes, whether it's done in my office or provincial office. If it has to go to CCMC, it is a bit longer, the constitutional case, but I will, we have discussed it already because this issue was raised by we discussed it at our national office. I will send the request if it has to go up to national office via round robin, but that'll take a couple, more than 2 days to finalize. And then obviously, I'm not too sure how long the expert will take to finalize his report and be ready. That's obviously It has to do with.
I thought he had started on the report, Mr. Mnisi. Has he started on the report?
Yes, my lord. As I've said, we've got a preliminary report. It's not like it's going to start afresh.
Mr. Baloyi, what's the state's view?
As the court pleases, I think in light of what Ms. Isola has said, we will abide by those arrangements that the issue regarding the cross-examination of Lieutenant Colonel Mangena, and it's Mangena, not Mangani.
Mangena, yeah, sorry about that.
Yeah. Some call him Mangena, but it's actually Mangena.
Mangena, okay,
Yes,
sorry.
Mangena. That the matter stand down for a month, as the court has suggested.
Yeah, is that okay?
Yes, that's it.
But it doesn't stand down for a month. When that month elapses, the cross-examination of
Yes,
Mr. Mangena commences.
yes.
We won't postpone it for a month, and then you come and tell me, yes, you know, my house was broken into. I had the disc under my desk or table. It means if we postpone it for a month, it is for the cross-examination of Mangena.
Yes.
So give me a date, all of you.
Well, today is the 16th of April,
Yeah.
so we're then looking at a date after the 16th of May.
Which is? Agree with your colleagues here.
Yes.
May-
The 28th, my lord. That is the next Monday, because the 16th of May is on a Thursday.
20th
Yes, the 28th. That
Of-
will be on a Monday.
of May.
Yes, I'm not so sure if that is.
Yes.
It's fine with my colleagues.
Mr. Gomezulu, is it okay?
Suitable. It is suitable.
Mamalo, don't have a case in Peter Marisburg.
It's suitable, thank you.
Ms. Mshololo? Okay, then it's agreed then that the matter regarding the cross-examination of Mr. Mangena will be postponed to the 20th of May for such an exigence. Is that okay? Thanks ever so much for your assistance.
It's a pleasure, ma'am. Please be excused.
Thanks, your excuse. Okay,
Family, I want to be honest and say, in my opinion, the defense had already forgotten about organizing this ballistic expert. You know, August, it's a long time. They had forgotten. They only remembered now as they realized that now it was time. Judge Ratha wanted to know what is happening. But otherwise, they did forget. Let's be honest. In the comment section, tell me, what are you saying? What do you think happened? Why the delay? And let's talk. Family, thank you so much for watching up to this point. And please do not forget to like this video, subscribe for my channel if you haven't done so. And for pardon me for my voice, I am catching flu. I'm not feeling well. Thank you, family. Bye.